Our next speaker, Arpita, Dutt, who's from the Russell, Jones and Walker solicitors firm, but also has been at all the BARAC meetings since the founding of BARAC and been heavily involved in supporting some of the initiatives and works around challenging the cuts and the inequality of the cuts. Some of the things that come out of the government, and our kind of legal advice, one of our legal advice experts really in the campaign is going to be speaking next. And I'll follow that to talk about
what I want to talk about just really is to set a framework for the law, the robust armoury, the sword that the law can provide in this area to challenge cuts. Not only on a collective level, but the fact that each of you in this room and everybody in Friends House Hall has the power to individually challenge the cuts using the law as armoury. And I want to give you a bit of background as to how that's come about and just talk about some recent cases to show you the power of this law. And the law is the equality duty. You've got a fact sheet there on your chairs, but I'll talk to you about that. And what the law provides around the equality duties is to enable you to challenge policy decisions made by public authorities, that's local government, councils, police, schools, all the decision makers, and to ask them and to require them to take account of the disproportionate impact of the decisions they're making on some of the most vulnerable sectors of society and our communities. And not only to take account of it, but to give advance consideration to it before they make the decision and give prominent consideration to it. So how did this all come about? Well, in April 2001, Parliament introduced the race equality duty. And this was followed in 2006 by the disability equality duty and then by the gender equality duty. And the background to introducing the race equality duty were the findings following the racist murder of Stephen Lawrence in 1993. The findings of the Stephen Lawrence Inquiry report of institutional racism and how that needed to be dealt with on an institutional level to change the fabric, the culture of our societies. So, having found institutional racism, the race equality duty was described as one of the most significant steps that the government could take on race equality at the time. And what the Labour government saw was this was a way of trying to eliminate discrimination in public services. But not only in internal organisational structures, but how services are delivered to members of the public. And it was said at the time that public services must recognise that it is no good paying lip service to race equality. They must ensure that race equality is at the heart of every organisation. When they're making decisions, it should be part of mainstream policy consideration. Later, when we had the disability equality duty, the duty became more pronounced because, as our colleague said in the hall, the public decision maker should address the need to treat disabled people more favourably, the need to promote positive attitudes and encourage participation in public life. That's what the disability equality duty was required to do. And what the equality duties provide is that if due regard is not had to them, you can challenge those decisions by way of judicial review. That's scrutiny by the courts of those decisions. So how effective has all of this been? What do we know has happened? Well, actually the courts have been very interventionist in the way that they have assisted community, charitable organisations, campaigning bodies and individuals to give shape and vigour to these duties. And hot off the press, and you would have heard this in the news yesterday, is the latest of those decisions. I've got the judgment, apologise, I only read it last night, it's a bit hefty and I'm going to summarise it. And yesterday's decision by the courts was this. You know that the Labour government introduced the Building Schools for the Future programme. And this programme was aimed over a 15-year period up to 2020 to rebuild or refurbish every secondary school in England, of which there are about 3,500. And by July of last year, 2010, 181 schools have benefited from Building Schools for the Future funding, and 98 new schools have been built. A further 735 more were in advanced stages of build, and many councils had already expended millions of pounds towards some of these schools that had not been built. So a challenge was brought by 6 county councils, local authorities, because Michael Gove, Secretary of State at the time and now, decided that at a particular stage of funding, this funding would be cut. And many of these local authorities lost their future schools. And so challenges were brought. And we had a decision from the courts that said this, in respect of the challenge brought by the councils. There was an abject failure to consult with the councils over the decision. And for that reason, the court said that the whole decision to withdraw funding needed to be reviewed. And it said this: however pressing the economic problems, there was no overriding public interest which prevented any consultation or justifies the lack of any consultation. And insofar as it affected the councils, the decision to cut the funding was unlawful. The absence of any consultation deprived the councils of an opportunity to remind the Secretary of State of what they claimed were unique or highly unusual facts to press their cases. So the judgment succeeded in favour of the councils because the Secretary of State failed to consult. But there was another limb to the challenge on which it also succeeded. And it succeeded on the basis that the Secretary of State had failed to give advance consideration to the equality duties. He had not, on a case-by-case basis, considered what impact withdrawing funding from these authorities would have to disabled school children, ethnic minorities, and on grounds of gender. And for that reason, the decision was unlawful. And now the Secretary of State is required to reconsider the decision in light of those duties, and as a result of which, some of those schools may be funded. Maybe not all, but some. So that was a decision challenged at governmental level by councils. But what have we also seen? We've seen 2 weeks ago the decision challenged and quashed to withdraw £10 million worth of grant funding to a number of charitable and voluntary organisations in London. And that decision has also been asked to be reviewed by the courts because the decision to withdraw funding from charitable groups who are involved in homelessness, domestic violence, gun and crime, anti-crime initiatives, all of that would have had an impact on our communities, and that was not considered before that decision was made. So that funding decision has been quashed in light of the failure to consider the equality duties. And I'll talk about one final duty, one final decision, because it was a local level decision. A couple of years ago, Haringey Council approved a multi-million-pound retail and residential project in Tottenham, in an area which comprised about 64% Latin American and Spanish-speaking traders. And these traders provided goods, services to the local community and the ethnic minority communities. And the Court of Appeal overturned, quashed the funding decision to approve the development. And why did they do that? Because despite finding there was lots of consultation through the planning process, the Court of Appeal found the Council's decision failed to properly address the adverse impact on the local ethnic minority communities who would have been disproportionately affected. But the big victory around this was that the claim was brought by an interested long-term resident. And that resident neither lived in the area nor worked in the area. They were a concerned resident. And that is the power of the individual, a concerned resident. And we are all concerned residents. We are all in it together. So, that is the armoury that the law provides. And that is something that we, within BARAC, have tried to utilise in effecting a legal strategy around some of these cuts. You know that there was a comprehensive spending review by the government, and that was announced in October. And what the government did when they announced that spending review was also publish an overview of equalities, how they had considered equality issues underpinning some of those decisions that they were making. And what we as BARAC did was look at that equalities assessment, and we found that it was scant, and it wasn't an equalities assessment. It didn't provide many answers to questions about how the disproportionate impact was being assessed. What data were they looking at? Who had they consulted? And for that reason, we wrote to the Treasury in November. We wrote to Mr. George Osborne, and we asked him a series of questions about how they had come to the decisions. What's the data behind the decisions? And we didn't receive a response. And we were told we were going to receive a response. But as of December, we had not received any response whatsoever. So we wrote again and again, and still to date we have had no response. And so what we have done is tabled some parliamentary questions around the failure to provide us with response to legitimate questions asking for how they've arrived at the assessment. We also have an early day motion going through Parliament that you will hear very soon, questioning and tabling the issue about equalities impact assessments and how are any of these policy decisions being arrived at without considering the effect on black people, on disabled people, on women. And in due course, this duty in April will also need to consider people of different sexual orientation, religion and belief, age, and other protected groups. So it will be wider, not weaker. And so we have a parliamentary strategy as well as a legal strategy where we are encouraging individuals to raise questions at local level. Raise questions of councillors, raise questions of the chief executives, raise questions of the mayor. Where is your equality impact assessment? What have you done to assess the disproportionate impact? And if you are a service user, if you are a member of an organisation and you are facing a cut and you have not been consulted, then where is that consultation and why has it not taken place? And these are all legitimate questions that provide armoury to legal challenges that could be brought, but also it gathers the momentum for the individual challenge on a local level. And it gives you the power to do it by email, by post, within surgeries, by turning up to the door of the council, however which way. They're legitimate questions, you have the legal right to ask them, and you have the legal right to get an answer to.